Thank you, Mr. Chairman. Mr. White, when Congress passed Dodd-Frank 12 years ago, it included Section 1071, which requires companies to inquire whether their customers are a small business, women-owned business, or minority-owned business at the credit application stage. However, in the 70s, Congress passed the Equal Credit Opportunity Act, which prohibits race as part of lending criteria. If the CFPB's proposed rulemaking would make financial institutions essentially guess the applicant's ethnicity if an applicant does not want to provide such information. It would appear to me that would be racial profiling, if I'm not mistaken. Mr. Wilson, does that proposed rule go against the Equal Credit Opportunity Act, which has been in law since the 1970s? Mr. White, I'm sorry.
As Mr. Wilson actually said earlier, we are concerned with having to guess the race of our customers. We have to do that under HMDA currently, but through PPP, we learned that a substantially higher number of small businesses decline to provide that information than homeowners. And so as a result of that, our employees are going to be guessing that information a lot more than what they do under HMDA. And that will eventually kind of erode the data. As we say in the banking industry, garbage in, garbage out with models. It will be very hard to analyze the data.
Okay. Equal Credit Opportunity Act is a law, though, is it not?
Yes. We cannot discriminate, period.
Right. This is a rule by the CFPB, right?
Yes.
Does the law overrule a rule?
No.
No.
Statute rules.
They are equal in substance, equal in importance. One does not overrule the other.
Statute technically, I think, overrides a rule, but we have to follow both. And as long as they don't conflict.
Well, would this not conflict here because you're basically racial profiling with the way the new rules proposed versus the Equal Credit Opportunity Act said you can't do that?
It certainly opens up the risk to that.
Okay, as an attorney, would you not be concerned by your officers opening yourself up to a lawsuit in the situation with if you comply with one rule here? Are you doing something in contradiction to the law?
It certainly increases our risk of opening ourselves up to litigation. That's correct.
How would you advise your customers or your clients in this situation? If you were a bank attorney and you're not the CEO now, if you're a bank attorney for a group of banks, what would you advise them to do here?
When the rule requires our employees to guess, there's not much more we can do than say, give it your best guess.
As long as you're guessing according to what the rule tells you to do, you're going to be okay.
Well, hopefully. I will say as a community bank, we know our customers.
Is that a way to do business?
No, it's
Mr.
not.
White, to guess what's going to happen?
We do not prefer to guess when it comes to doing business.
Thank you for that. Mr. Peters, you made a statement a minute ago that each bank has to collect the data and report it, even if you do not make the loan. It would seem to me like that's going to skew your data if you're going to have to continue to report it. Somebody who's not a worthwhile individual, he goes to 7 different institutions and gets turned down. It's going to skew the data, is it not?
Yeah, I think definitely so. You know, most times a small business is not going to just go to the first lender. They're going to shop their deal and try to talk to a number of banks about it. The banks are also going to help them put together the structure of that loan. So it may look different in different applications in different spots, and only one bank will fund the loan, but they will all be reporting the data, and I think it would be very difficult to find meaning in that kind of data.
Mr. White, the CFPB not only wants to collect a series of personal and detailed data from small businesses, but refuses to release which information they will publicize or share how they plan to make that determination. My bill, the Business Loan Privacy Act, would require the CFPB to do a separate notice and comment rulemaking to determine what information will be published by the Bureau. Mr. White, do you believe the CFPB should have a separate rulemaking for this, allowing small businesses and lenders to be part of the conversation?
Absolutely. And on behalf of ICBA, I would like to thank you for that legislation that you have introduced. Small businesses, community banks should have a voice in what data is made public, because that's where our privacy concerns come up for our customers.
Well, it looks to me like your clients, your customers' information is going to be much more public than what it is now if this goes through. Do you have concerns about that information being made public and having some ramifications of that to your customers?
We do. Small businesses prefer their information to remain confidential, and when our customers realize that their data is being made public, it provides an incentive to go to a larger bank where their information can basically be hidden in the data. And if they come to our bank, like that butcher I talked about, everybody's going to know who it is. But if
So
you
what-
go to a big bank, he may
So
not.
what you're saying is, instead of being able to do business with your local community bank, if you prefer not to have everybody in the community know what you're doing and what your business is, you may go down the road to a bigger bank or some other community, and as a result, you're not doing business with your own community bank any longer.
That is exactly right.
So it will hurt the community banks by doing this.
Highly likely, yes.
Okay. Thank you very much for testimony today, Mr. Chairman. I yield back.